Welcome everybody to volume 6 of McBraer's Scary Stories. This year we've entitled it, Who Killed the Non-Competes? And I think it's an aptly named title for this year's webinar because we've had a lot of changes in many aspects of the law, and there are a lot of changes to come. And so today what we hope to do is give you an idea of how to plan and prepare for the upcoming year and to be aware of some of the laws and regulations that you didn't expect would apply to your business. So we have a lot to cover, so we're going to go ahead and get started. So our first mystery relates to the latest decision from the United States Supreme Court regarding religious accommodations. Here's our scary story. The calls are coming from within the house. The call is requesting accommodations. You're not sure which requests you have to work with and which are beyond your responsibility as an employer. How far will you have to go to accommodate employees? And importantly, what standard applies to the undue hardship tests? So our first poll is, which of the following is not grounds for accommodations under federal law? A, location of residence, B, physical disability, C, mental disability, or D, religion. Go ahead and we'll take a few minutes for you to input your answers.
Seconds, we stop.
All right, that one was obviously too easy. Location of residence is definitely something we do not have to accommodate. So let's skip forward and hold on.
Did I share the results? Oh, yeah. All right.
Let's talk about this United States Supreme Court decision. Okay, we're stuck. While we fix that, I'm going to continue to talk before we get our slide up. So the United States Supreme Court, oh, there we go, issued a decision entitled Groff versus DeJoy, and it changed the test for what is undue hardship under a religious accommodation standard. You know, for 50 years, we had really very little decisions, very few decisions related to religious accommodations. And, you know, scary story, COVID hit, and that sort of reignited our analysis of religious accommodations and undue hardship. Timing of that was probably perfect with this Groff case, because in that case, we had a postal worker who sincerely celebrated Sunday as the Sabbath and wanted to attend church service, did not want to work on those days. And ultimately, when he was required to do so, his employer, the Postal Service, said, look, if you can get someone to cover, that's great. But if not, you've got to take the shift. We aren't going to make employees cover for you because under the old de minimis standard for religious accommodations, we didn't have to. So he missed shifts and he was disciplined, and ultimately he quit. After he quit, he sued for a violation of religious accommodations. So what does this mean? So we went to the Supreme Court, and the Supreme Court decided that the undue hardship test should look more like the ADA's test, which requires a substantial hardship to the business, meaning an economic burden. So what this means now is you are going to have to, in deciding and reviewing religious accommodations, if you have an undue hardship analysis, it's going to look more like your ADA analysis, where we have to show some substantial cost. Having an employee cover is not going to be a substantial cost unless there's, you know, perhaps an overtime issue or something that has that economic tie. So we need to make sure that your employee handbook is up to date, that your religious accommodations policy isn't different from the ADA policy. And when you get these religious accommodation requests, be mindful of the new standard and how you communicate and how we address them. Another frequent accommodation request that I have been receiving more and more lately relates to mental health accommodations. I have seen PTSD, anxiety, depression, OCD, ADHD, and more employers just don't understand how to accommodate them. And then oftentimes, be honest with you, they're very difficult to accommodate. I'll give you an example from a case that we're handling at this time. You've got an ADHD employee with ADHD who wants more feedback, more attention, more one-on-ones in order for her to better understand how to do her job. It's a very vague and ambiguous sort of accommodation request. And in her mind, it was, well, I need this to help me focus. So it's really difficult to analyze whether or how an employer can and will accommodate that. So because of the increased understanding of mental health concerns and the increased sort of awareness of it, employers are seeing more and more of these requests. It's going to be difficult to address them. Also want to identify another one that we dealt with on OCD. We had an individual employee who had OCD. Part of her job was to clean a restaurant. Well, she couldn't clean the restaurant in a short amount of time. It took her 2 hours to do what would have otherwise been a 10-minute job on certain tables and areas. And she wanted an accommodation to get extra time because she was OCD. Was that unreasonable? Probably, but it creates a very difficult analysis, much more difficult than a physical disability where we're looking at, do we need a back brace? Do we need time off? Do we need standing desk? So we've got some sort of tips to address these when you receive them. So the first thing I want to point out is this might be a difficult thing for the employee to admit, and it might be risky. Because it might be something that's super private to them. They're worried about people talking about it in the workplace, gossip and rumors. So it's your job in HR to make sure that that doesn't balloon out. So one of the things when someone comes to you and discloses a mental health issue that needs an accommodation, most importantly is to just listen, explain, should be supportive of them. And this don't overpromise is really, I think it's human nature to say, we're going to help you, we're going to get through this. And those statements can then be turned around that you've promised something that you either didn't or couldn't. Make yourself somebody that they can talk to, right? So one of the things that we want to look at here in this process when they're opening up to us is, again, to just listen. Have them identify what accommodations they think they need. But again, don't promise that we can handle that because it could be a slippery slope. In an example where you've got an individual who has, some sort of anxiety and their boss creates anxiety for them because the boss is too demanding or gives too much work. How do we accommodate? Do we accommodate that? And if we do, what's the slope of that? Where does that go? So again, listen to them, take their lead, what they want to share. There might be some information you need from them in order to fully analyze it. And if so, explain to them that you're only asking for follow-up information to better understand how we can accommodate, if we can accommodate. Think outside the box and come up with some sort of flexibility with respect to the religious accommodation. And I would also be very open and candid about what can and can't be done. My example of someone who needs more feedback, more one-on-one time. Why is that impossible, right? Do you already have access to an open door policy? Are you already receiving feedback? Does this supervisor supervise 10 or 12 other people and there isn't that time for it? Explain sort of the practicalities if it's something that's difficult to accommodate. Explain sort of what it is that we can and cannot do and be really open and honest about that. On the don't side, we don't want to make a big deal about the disclosure, even if it's someone that you have familiarity with. We just want to have it be a very neutral environment. So this is not, whatever it is they're disclosing on the mental health side is not a big deal. Again, don't overpromise. We got to think through it. And I would say, at the end of any conversation, just to say, let us think about this. Let me talk to your supervisors. Let's get maybe I follow up with them, have them submit an email, what they're looking for, and take a minute to think about it. Of course, if you need counsel, reach out to your attorney. And again, this is about trying to figure out what's best for everyone. So there are examples of accommodations given by the EOC with respect to mental health. Some of these might work and some of them might not. An altered break schedule to accommodate therapy appointments, that should be fairly standard and easy because it'd be the same as a physical disability. Specific shift assignments, if an individual, for example, who has ADHD and is trouble getting up in the morning because of they are unable to discipline themselves to go to bed on time and it's completely tied to their ADHD, maybe we put them on a different shift. Permission to work from home, if there's an anxiety issue, perhaps that is something that we can address. Obviously, leave of absence, that would be the last one I would tend to look towards, but unless they needed leave of absence for some to regroup in some way. But you're going to have to really think outside the box. I'll also remind you of the JAN network, the Job Accommodation Network. It is a resource that can be used for you and the employees to look at some alternatives to some of these more difficult accommodation requests, because every situation is unique. And so I just, ask that, you think about things in a outside the box. If you're going to do something as a trial period, be sure that that is clearly communicated and in writing, and why you're doing it as a trial period, because it might work, it might not. You don't want to be committed to it, and you can't revoke an accommodation once it's given. But if you say, look, we'll look at this after 4 weeks, this say permission to work from home. After 4 weeks, we'll see if it's working for you and your supervisor and your coworkers, and here's why. Here are our expectations. And if it doesn't work, then it's something that you can, if you do it right, you can revoke it. But be very, very clear in those communications. So the takeaways from this, just generally on the religious side, again, review your handbook, make sure that your policies are clear, and really understand your obligations if you're going to deny on an undue hardship basis. And on the mental health accommodations, it's obviously easy to be skeptical, but that skepticism leads to claims, period. If you are skeptical in your communications or negative with the individual, even if you're, deny the request, being supportive of them goes a really long way. Otherwise, it gets turned into a perception of a disability or a retaliation claim, and that skepticism can work against you. So those are the takeaways from those. Our next mystery is one that we actually visited about a decade ago. At first, you think it's just the sound of the building settling, but the creaking and crunching has been impossible to ignore. Your head seems to be getting awfully close to the ceiling, and it seems that the floor is getting higher. That is the salary floor that determines which of your employees is eligible for overtime pay. So our next poll relates to the proposal from the Department of Labor to increase the salary floor for overtime exemption from $684 a week to what? So we'll go ahead and open that poll. All right, we'll end the poll and we'll post the results. So the correct answer was $1,059. And that is a huge increase, as you can obviously understand and expect. Now, if we recall back in, there we go, thank you, Claire. Back about 10 years ago under the Obama administration, the proposal was at about this rate. It was about up to $1,000 a week to raise the salary floor, and it got rejected for what is currently in place, a $684 a week guaranteed salary, or $35,568 a year. And at that time, the increase, had been no increase for over a decade. And so it was something that was necessary, but I think that the jump there from, gosh, I want to say it was $400 and something to $1,000 was too much for employers to bear. And there was a lot of pushback against it. But now we had this back a few years ago to $684, and now the Biden administration is seeking to increase it to this $1,059 threshold. So what does this mean for you? Just like we talked about 10 years ago, it's going to take a lot of planning, because what's going to happen here is anyone who's on a salary, who is exempt and who has exempt duties, who is earning over $35,000 $50,000, we will need to be paid a salary of at least 50, oh gosh, what was it? 55,000, and that 1059 a week. So that could be a budget buster for a lot of you to increase those individuals' pay. Let's say they're making 35 now, we got to increase them $20,000 to make them exempt from overtime. Might not be practical. If it's not practical, then they must go to a non-exempt position and get paid overtime for any hours over 40. So you have to do the math on that. So you're gonna have to sit back and take some time between now and the end of the year and make a plan for that. But what comes with that, I think, is some intangibles. There's a loss of prestige that you're no longer on salary, that if I don't work 40 hours, I don't get paid, my paycheck won't be the same every week. So we're gonna have to have a lot of communications with our employees that are affected by this, who you are going to switch from exempt to non-exempt and make them eligible for overtime pay. You're also gonna have to decide, what that budget looks like. Those individuals are now gonna have to clock in and out. They're gonna have to get their breaks and lunch periods. And so they also might view it as a demotion. You're gonna have to handle that head on. It is not a demotion, it's a difference in pay due to this regulation. And so, more importantly than just the financial aspect of it is the human aspect. And so you're going to have those conversations with people who are affected. If they're getting a raise, that's a great conversation, right? They're gonna get a raise, they're still gonna be exempt and salaried, but if they're not, and they're gonna be turned to non-exempt, it's really important to have a meeting with them and explain the intricacies of it and why, that it's not you, that it's the government, that this law has now changed. So it is it hasn't gone into effect yet. You'll keep an eye on our blogs and the news to see when it does. Not sure if it'll be that 1059 rate, but we now need to expect that and plan for it. If it's less, let's say it goes to 800 something instead from the 600, that obviously is a different financial impact, but you need to prepare for it right now. So next I'm going to turn this over to Claire, and she is going to talk about some baffling mysteries related to laws that you may not be aware affect your business.
Hi, y'all. So the first thing I want to talk to you about, most of the stuff that I'm going to be discussing relate to the National Labor Relations Act. And just so we're clear, if you have 2 or more employees, the National Labor Relations Act applies to you. It applies to every employer with 2 or more employees. And what does the Act do? The Act protects your employees' rights to bargain collectively, either with a union or to engage in protected concerted activity. And what does that mean? That means discussing or in some way getting together to adjust or address their wages, hours, and working conditions. So when folks have that rule that says you're not allowed to tell employees how much you make or what your salary is, that's an unlawful rule because of the National Labor Relations Act. Okay. So as I've mentioned for years now, the National Labor Relations Act is interpreted by the National Labor Relations Board. And they change with every administration. So every 4 to 8 years, you might see a seismic shift. And that's what we're seeing now. With Trump, he changed the case law, his administration changed the case law and became very, very conservative, very, very employer friendly. Now we're kind of going back to the pre-Trump days, to Obama, and really to what the case law was for roughly 40 years. And so we're shifting. Now, I will say that the Biden NLRB is shifting way past what it was for the 40 years. And I'm going to get into that. I mean, Cindy and I were talking about this, and I was knocking her socks off on what some of the holdings have come out recently.
That's an understatement.
That's an understatement. Yeah, she had some very emotional feelings. And so if you have emotional feelings, please do not blame me. This is not me. This is the NLRB. Oh, so the scary story.
Oh, go back.
Whoop. Okay, sorry about that. For 2 years now, technology and I do not get along. I apologize.
There's a little delay too.
Oh, that's what it is. Okay. For 2 years now, there have been whispers that the dreaded handbook phantom of yesteryear will return. Now your fears have been realized. Your trusty employee handbook, designed to support your business and workers, has suddenly turned to one that can stab you in the back. That's actually an understatement. Okay, so here is the poll. Employees must maintain a respectful, positive attitude at work. and are prohibited from making disparaging comments about the company, coworkers, or clients. Is this handbook policy lawful? All right, we're going to open it up. For some reason, we have to close that, that's why. Okay,
It's, it may be waiting for me too.
oh, okay,
So we're sharing.
okay. Well, I'm gonna cut ahead until we get this going. The answer is no. It is not a lawful policy. So we're gonna talk about this, so I'm not gonna break through. For the last, let's see, 2 years, the NLRB has made clear that targeted employee handbooks and sources of policies may infringe on Section 7 rights. So again, your Section 7 rights are your ability to bargain and engage in protected concerted activity, what we discussed before. So it's clear that the NLRB has historically said you cannot prohibit your employee from disparaging your manager, your company. You can your business, but not your coworkers. Pre-Trump, once Trump came in, the entire standard changed and it created this new standard in which it was very employer positive. We're going back to the pre-Trump standard in which we're looking at whether or not an economically dependent employee would reasonably believe that engaging in this protected concerted activity, so maybe it's talking to your employees about how much you hate your supervisor, would reasonably be interpreted to restrict their ability to talk about wages, hours, and working conditions. So that's the new standard. We're going back. So let's talk about what that looks like in practice in terms of your handbook. It would include, you cannot disparage your employer. It would also include things like, it's probably unlawful to prohibit recording conversations with managers. Because again, the employees might want to record those conversations to discuss those later to protect themselves against any kind of adverse employment action. Not disclosing company investigations. We all do this when we're conducting investigations. The human resource manager looks over and says, this is a very sensitive topic. We want to keep it confidential. We want to make sure all the evidence that we receive is unbiased. I'd appreciate it when you leave this room that you not discuss what I've asked you here today. It is unlikely that that will continue to be a lawful policy. Not behaving in a way that would damage the employer reputation. Some of us have handbook policies that say something like that. That would probably not be unlawful. And so when you think about it, it kind of makes sense in that if they go out and they post on their Facebook page, you know, McBrayer, it doesn't pay, you know, appropriate wages and business and, you know, our benefits is not great. Hypothetical, they're wonderful.
McBrayer is great.
They're great. But if somebody went on their Facebook page and said that, clearly it would damage McBrayer's reputation. And they might get upset if this individual was acting with others, discussing this issue with others, including just a like on their page. Another employee likes that page. That would probably be protected concerted activity. See, now you know why Cindy was mad. Yeah, okay. So let's continue in the story. One day, you're in a meeting explaining a new overtime policy to a group of employees. One employee stands up and says, screw you and the horse you rode in on. We don't have to stand for this BS. You're worse than the devil and everyone hates you and thinks you are a terrible person and an even worse manager. So here is the poll. Can that employee be fired for insubordination? Okay, I'm impressed. Most of you guys got it right. The answer is no. And it relates, I'm gonna let him stop sharing.
Back to this, here,
Let's see. So the answer is no, and there's a recent case called Lion Elastomers. I'm probably,
Did you show it on yours?
I think when I do it that way, I have to, yes. It was May 2023. It overruled a Trump era precedent that gave employers more leeway to discipline workers for outbursts. So this goes back to the handbook rules we talked about. Can you have a handbook rule and enforce a handbook rule that that prohibits disrespect? No. Can you have a handbook rule that prohibits unprofessional conduct? No. Can you have a handbook rule that prohibits insubordination? No. And so here's the not reenactment. Here is the example of that occurring and how you are supposed to react to that. Now, if they had said something like that and it had nothing to do with wages, hours, and working conditions, and they're just assaulting a manager verbally, then yes, you could do whatever you want. The question is, does it relate to protected concerted activity, wages, hours, working conditions? Are these folks talking about something that affects those issues? And if they are, then we're using a different standard, right? So one of the problems about this ruling is employers have to manage two different standards. One that relates to insubordination and disrespect related to just general stuff, and one that relates to protected concerted activity, which is hard when you're trying to think about all of the Title VII stuff and you're trying to think about all the other EEOC laws and you want to apply your rule in a non-discriminatory fashion, right? So now you have two separate standards that you have to juggle. All right. So what this case says is if it relates to protected concerted activity, so that's the first question, does it relate to protected concerted activity? And the answer is yes. We then ask, well, did that employee, was their behavior so egregious that they lost protection of the act? And to figure that out, we look at this 4-factor test. And we talk about the place of the discussion. Was it private? Was it a couple of folks? Was it a huge room? Was the subject matter of the discussion relevant to their wages, hours, and working conditions? What was the nature of their outburst? If they punch their supervisor in the face, they're going to lose protection of the act. If they swear at them, they're probably not. And then, was the outburst in any way provoked by the employer's unfair labor practice? Now, keep in mind, if that employer was enforcing an unlawful rule, a per se unlawful rule that you have in your handbook, that is provoked by the employer's unfair labor practice. So this all weaves in, and it really does play against the employer's ability to enforce their own rules. Okay, so I know you guys are mad at me about that, but you're really gonna get mad at me about this one. Okay, so the most radical decision of the board just came out. It essentially offers the union a way to circumvent the election. So what I think union advocates have been doing for a really long time is trying to get essentially card check certification, where a union or a union rep can come up to an employer and say, hey, we represent the majority of your unit or your employees, and we want you to recognize and bargain with us without an election. Okay, so that's a card check certification. Here's the problem with that. Authorization cards are historically very unreliable, because when unions hand those cards to employees, what they say is, hey, listen, this is just so we can have a union. You don't have to decide whether or not you want us as your representative. There's going to be an election for that. Don't worry. We're just giving folks the option of this. We just want to give you more information. We just want to open the door so we can have this conversation. But that's actually not true. And it is not an unfair labor practice for the union to lie to you, which is really, really weird. But it is not an unfair labor practice for the union to lie to all employees and tell them whatever they want when they hand that card. So as a consequence, there's a percentage of people who sign those cards not realizing that they can be used to circumvent the election and to get a bargaining order. So back to the rule. what Simtex basically said was, if the union comes up to you or union rep comes up to you and says, I have a majority of cards and I want you to recognize the union, before this case, the employer could say, go jump off a bridge and come see me when you have an election petition filed with the NLRB. Now, what would happen is the employer is responsible for filing that election petition within 2 weeks. And if they fail to do so, the NLRB can issue a bargaining order. Now, there's a whole mess of things that can happen and that the employer can challenge it, but now the onus is on the employer to protect themselves. And to add insult to injury, the NLRB said in the same case that if there are any ULPs committed by the employer that could have affected the election outcome during the election window, which we're going to talk about later what that means, that the NLRB at their own discretion can issue a bargaining order. So basically, there's now these two wonderful ways that the union can get in without ever having an election. And this seems insane and radical, and it is, and you would think that this would be challenged, it would never happen. But August 28th, Trader Joe's United became the first union to request a Simtex bargaining order. September 28th, 2023, the NLRB through an ALJ issued the first Simtex bargaining order. And so these things are happening now. Okay, so what do? What you do is you have your handbook looked at, which you should do anyway, because Cindy told you to, and we listen to Cindy whenever she tells us to do something. And then you work with them with an eye towards the NLRB, right? To make sure that these policies don't violate the NLRB. Next you do, and I don't know if I have it on this slide or the next, but the next thing you do is you make sure that if you have any unions sniffing about, which pay attention to handbooks, to flyers, to whispers, to folks avoiding managers, that you really pay attention to that and you call your labor attorney. Because if a union comes in and hands you a bunch of cards, you want to be ready and you want to know that you have to file a petition within 2 weeks.
So before you move
Yeah.
on, I want you to address, you and I talked about another scary story that that there are activities that they're looking, or the general
Yes.
counsel's looking for test cases. Can you talk to them about,
Test cases regarding Simtex
or just test cases in general that they're looking for? You know, we think this is sort of maybe rare, like
Yes.
Trader Joe's is the first, but that they're actively looking for.
So with all these handbook rules, what happens is when you have these changes of administration, they will issue a ruling, but it won't deal with everything that occurs. So what I have been seeing a lot is things that are occurring, union BAs who are pushing the envelope, or employees who are pushing the envelope. Maybe they're a plant from the union, or maybe they just are being coached by the union to do things that they wouldn't ordinarily do, in order to bring all of these issues before the NLRB and overrule all of these issues. So
Even if you're not a union shop.
even if you're not a union shop. So you might have something, we had a client the other day who was disrespectful to their union, to their manager. Hadn't really been before. It was a new employee, came from a union shop, was a new hire. And we suspected that that guy was basically pushing the envelope to see if he could get fired for insubordination. Because he wanted that up to the NLRB. He wanted to create an environment in which the union could come in and get certification for the majority, which he said he had. So that's what we mean by a test case. And so if your employees are acting a little bit weird, or if there are these issues coming up, we want to make sure we address them. Okay.
Sorry to interrupt you. I just thought,
No.
That
Yeah,
came up the
that's
other
fine.
day.
I know, it died, yeah. And then, so the next thing we're going to talk about is the incredibly shrinking bargaining units. Okay, something strange is happening at your workplace right before your eyes. Things to be shrinking, but without warning. First, bargaining units start getting smaller and smaller. Then union election timelines begin to shrink by days and weeks, leaving you with little time to respond. As bargaining units and election timelines get smaller, your problems only seem to get bigger. True or false? The changes to the bargaining unit formation and union election timeline represent. Oh, can we not do this poll? by the way, Brian?
Yeah, we.
Okay, I'm gonna skip this because we've already talked about the fact that it is, the changes represent Obama era standards, and we got a lot to talk about. Okay. So return of the micro units. I'm just gonna go straight into that. There was a case that compressed the units, the bargaining units. So whenever you have a petition for an election, the union basically decides what that looks like. And I'm gonna go, the prior standard was set by a case called specialty healthcare. And basically what it did was it compressed the union standard completely changed. Now, the reason that somebody wants a micro unit, an employer does not want a micro unit, an employer wants the biggest unit possible, because then the union has to convince the biggest group of people possible, 50% plus one, to agree with the union and to vote the union in. If it's a small unit, like let's say a 2-person unit, then really they only have to convince 2 people. Or if it's a 3-person unit, they only have to convince 2 people. And once they convince those 2 people to support the union, then the next thing you get, oh, I don't know what just happened. Then the next thing you get is a union in your shop. And they might not represent all the folks, but what they do is they now have access to your shop through that represented group, right? So it's in their best interest in terms of bargaining to have the smallest possible unit. Okay, so we have returned to the specialty healthcare standard, and that means that the unit that the union chooses is a presumptively appropriate unit. And the employer, not the union, has the burden to show that that petition for unit is inappropriate and that 2 other units should be joined and that they have an overwhelming community of interest. So whenever you have these units, you kind of have to explain why these people go together and why other people should be excluded. Okay. The next issue, so we're seeing how the law is favoring unions. The last issue is the return of quickie elections. So recent NLRB decision reverses the 2019 rule about union elections and returns to a quickie election rule. This change was really directed through rulemaking and not just case law. There was no notice and comment period. The NLRB just did this themselves. It takes effect December 26, 2023, so right around the corner. What does it do? If you have an election, hang on real quick. Can you stop doing that? Or is it that?
It's.
Sorry, we had technical difficulties, so I was blaming on Brian, but it was not Brian. Okay,
It's
so,
me some way. I just don't know how yet.
That's okay.
okay, sorry, it was just very distracting. Okay, so anyway, going back, when you have that, the employer now has to file a petition in order to get an election to avoid a bargaining order. Well, now that period of time is really shrunk. Why does that matter? That period of time is where the employer actually has the biggest opportunity to educate their workforce as to why a union might not be good for them. Up until this point, it's very, very likely that the union has had the employees here and have been working with them for months, I mean, literally months, saying, oh, how terrible the employer is, how everybody has it better, how you're a fool not to have a union. And you, as an employer, probably had no idea this was going on, right? But now you do, because you've got this petition for election, and you have only that period of time until the election occurs to really talk to the employees and kind of change their mind and redirect all of that misinformation. Because remember, unions can lie. We can't, but they can. So now you have only that period of time. Well, if the election period is shrunk, you have very, very little time to be able to communicate with your employees about that kind of stuff. So how short are we talking? Pre-election hearing used to have to occur within 18 days. Now it's 8 days. The postponement period used to be however much you needed. If you couldn't get there in 18 days because of work responsibilities, you had an unlimited amount of time to postpone. Now you have 2 days. And the one that really chaps my hide is employers have to submit their briefs on the petition within 7 days of receiving notice. It used to be 17. And now the union, who had to respond before, 2 or 3 days, I think it was 3 days before the hearing, now doesn't have to respond until the day of the hearing. They can respond orally. So that means the employer is going in having no idea what the union's going to say, right? So again, we're shifting towards a very pro-union stance. Okay, so what this results in is election can be held 3 weeks after a petition is filed. So you might be in a situation where you have 3 weeks to talk to your employees about why they shouldn't join a union when you have never talked to them about this before. Okay, so what are the takeaways? The takeaways are you should probably know a labor lawyer and have them on speed dial just in case. You should also really kind of institute a labor relations plan where you're consistently talking to your employees about what you do for them, why your benefits are great, why they make a lot of money, why they should be proud to work here. And so even though you might not know the union is coming at your door, that's good just for morale, and you should do it anyway. Okay, last thing I'm going to talk to you about is who killed non-competes. This kind of doesn't relate to the elections and things like that, so we have a totally different section, but the NLRB, of course, did weigh in. The general counsel issued a memo basically saying that from now on, non-competes are verboten. They say that they are overbroad generally, and that they chill employees from engaging in protected concerned activities. How would that happen? Well, they want to allow employees to resign, to go to a union shop, and if you have a non-compete that prohibits them from doing that, then they cannot. If they want to call up their buddy and say, hey, Cindy, I know you worked at this law firm, prayer is the bee's knees, you should come over and move here, you might be violating a non-solicitation. And so this employee can't change her wages, hours, and working conditions by coming to a new employer. Can't solicit employees. And so solicitation is off the table. And the idea is seeking new employment is a way in which employees can affect change in their wages, hours, and working conditions, and non-competes restrict that. Accordingly, they're in violation. The practice, we are not sure how this is going to pan out because, again, it is a memo, it is not law. But we're going to see, going back to those test cases, if employees start coming in and saying, I want to go over here, or this person made me sign a non-compete and I want to challenge it, those test cases are going to come up and we're going to see what the NLRB actually says. And now I'm going to turn it over to Cindy.
Well, we are here at Who Killed a Non-Competes, which is our title mystery, and I'm sure it's everything you've been waiting for. It is, I think, something that every single employer is going to have to think about moving forward from today and plan for. And it truly is a scary story for some, and it's a joyful story for others. So let's look at the first scary story on the non-competes. For years now, non-compete agreements have been your close friend and a trusted ally as you work to protect your trade secrets, client base, and more. But after 2 recent attempts to take down non-competes, you're starting to get worried they may soon be gone, even before you have a chance to say goodbye. So our poll is true or false. The new proposed rule by the FTC against non-competes will prohibit new non-competes, but would also allow existing non-competes to remain in effect. True or false? Thank you. All right. All right, let's show the results. And the correct answer was false. So in the news recently, we heard earlier this year that the FTC was proposing a rule that would prohibit the not only enforcement of old non-competes, but would eliminate non-competes altogether. And I'll just tell you, the reason I think for this very drastic rule is because some employers have really gone overboard on their non-competes. And there has been a lot of pushback from employees, especially as our workforce gets older and we've got individuals who have been, working in an industry for 10, 20, 30 years, and a non-compete prohibits them from moving, effectively eliminating them if they're too broad from really working for a year or two or more. Also, some employers tried to impose non-competes on positions that really didn't need them. I've seen them go down to even a receptionist who would not really have any sort of ability to affect competition if the receptionist moved. So there's been a movement. A lot of states have already enacted laws that restrict or limit the use of non-competes. And in some states, they're really unenforceable altogether. So this FTC rule came out earlier this year and they received so many comments that they extended the comment period and we still don't have a final rule. But the proposed rule would make it illegal for employers to enter into a non-compete, to maintain a non-compete, or represent to a worker that they're subject to a non-compete when they are not. This also would require employers to take specific action. And this is the one that, we've been talking about things, I think Claire said that chaps or hide. This is one that I think will fall in that category. If this rule goes into effect, every employer will have 180 days following the publication of the rule to notify all existing non-compete employees under non-compete that it is no longer in effect. This does not just mean you tell your existing employees, hey, by the way, if you want to go quit and join our competitor, you can because our non-compete doesn't apply anymore. But you have to actively find all of your former employees who are currently under a non-compete where the restricted period is still in effect and let them know that it has been rescinded. And you have to go and find them using any means possible. And so that to me is a very high burden to track down those employees. Hopefully you have, an email address or something, or where they are, and you can put into effect a manner in which you can prove that you've given them notice. We haven't seen the final rule, but I would imagine there will be fines or penalties if you don't engage in these two proactive means. But practically speaking, when you tell your employees, hey, this non-compete isn't in effect, how does that affect your workers and what do they do with it? I think, Claire said a minute ago, it's good practice to remind your employees about what a great place you have, the benefits they have here and why they shouldn't want to go to another employer because the grass isn't always greener. So I would start, it for many reasons, if you're not already doing your own PR campaign to do that within your workplace, if you're at a workplace that has non-competes. There's also a worry that even if you don't have a non-compete, that a de facto non-compete clause could fall under this rule, which would include a non-solicitation or a non-disclosure agreement or a confidentiality agreement. I think, and this is me guessing, that a non-solicitation agreement that doesn't actually look like a non-compete will be enforceable, and non-disclosure agreements as well. I don't know that the rule is going to go that far. Because non-solicitation, just protects your client base. It doesn't prohibit them from working for a competitor, but prohibits them from soliciting your clients. So they can still work. They can still work in the industry. And so I'm hoping that the final rule does not affect something like that, unless the non-solicitation truly is a non-compete. And I'd be hard pressed to see the rule eliminating non-disclosure and confidentiality agreements simply because those have wide-ranging not only support, but I think they're universally accepted. This is Claire's very, very scary story on what the NLRB is doing. They're obviously trying to kill the non-competes from their angle. And so to the extent that, again, even if you're not a union shop, that you've got an employee that wants to challenge a non-compete, plaintiff's attorneys can be very creative, and if they get a hold of this memo, that might be part of their defense, and it's something that we need to be prepared for. So the takeaways. This is obviously a major shift, and you today need to start planning for it. I do believe that there will be some restriction on non-competes, not sure how broad it will be. So if you are an employer that uses non-competes, keep in mind that anyone from today, keep in mind, we might have to change how we do it. So you might want to consider now doing it differently, just doing a non-solicitation agreement, narrowing it to something that we think will still be appropriate in the future. If you have existing non-competes and you're worried about them going away, let's today go ahead and enter into a new agreement that allows them to compete, but protects your client base and your trade secrets. Again, I don't know what the final rule will be, but that seems to me to be at least a way to still protect you from this magically going away. Because once it goes away, good luck getting your employee to sign something new. So if you are an employer that uses this, be mindful that it might change. But let's look at it positively. If these non-competes go away, you can poach from your competitors. All of those people who are off the table because you knew they had a non-compete, they become on the table for you. And so I hope to end all of this negative talk for the past hour with something positive, something less scary, that now you can perhaps find some really good talent. So look at those alternatives and try to figure out how we're going to address all of these issues that we've talked about. So we have come in under time, and I always say,
Which is insane.
it's insane, but we need to get credit because I'm getting you to lunch sooner.
Yeah.
But we will be here for the next few minutes. If anyone had questions, you can put them in the chat and we'll answer them, or at least do our best.
Yeah.
So the first question, thank you. What did you mention as an alternate policy to start using now in place of a non-compete? My alternate policy would be to limit it to a non-solicitation and non-disclosure. And limit it specifically to those clients or customers that they either knew about or engaged with. Because I do think that it's going to be, I think that there's not a whole lot of support for a blanket non-solicitation would also be prohibited, because it still allows employees to work. And that's been the biggest sort of impetus in this new FTC rule is, can they move from place to place? Can they find a job in an industry that maybe they've worked in the past 10 years or 20 years or more? So I would, at this point, consider solely doing non-solicitation agreements and having them be fairly narrowly tailored, including a non-disclosure as well. Do you have any?
No, I would agree with that. The other thing I would say is, make sure you're keeping lists of who you have restricted covenants with, because there might be, I'm not saying that there definitely will, because I don't think we know the answer to this, but there might be a retroactive effect and notice requirement.
Oh, there will be. That's in the rule, yeah.
Yeah, and so I would keep records of who has what.
Yeah, it might be good. That's a good point to go through your employee roster. And if you had a 2-year non-compete, let's look back 2 years for anybody who who's left in the last 2 years and identify them now, so that if you're under that 180 days, that can go real quick.
That can go really quick.
Because you're gonna have a lot on your plate, especially if all these other things happen, like a new salary threshold and many other things. This recording will be sent to, could be available for all the participants. Will it be sent out?
Yes, we will be sending a copy of this recording along with a copy of the slides out to all registrants for this webinar, and we thank you for attending.
Yes, thank you so much. Reach out to us if you have any other questions. We're always available.